Hi, everybody. Welcome to our Wirewheel Spokes Privacy Week events. We're going to be starting here momentarily. I can see a lot of friends and colleagues joining in already. We have a terrific and very important guest today joining us here momentarily. I'm just going to wait until we have a little bit of a slowdown of folks joining today's session. Okay, well, here we go. Thanks again for joining our Spokes Privacy Week session. And we have a really terrific session today. I'd like to introduce Stacey Schesser, who's the supervising Deputy Attorney General at the California Department of Justice, which has been doing some very, very important work for the last several years in terms of developing and working on the regulations to actually implement CCPA. The California Attorney General has been enforcing CCPA and is obviously a critical part of the infrastructure in California together with the new Data Protection Agency. So I'd like you all to join me in welcoming Stacey Schesser to our session here today. Stacey, welcome.
Thank you. Thank you so much for having me. It's a pleasure to be here. I have to give my typical lawyer disclaimer. These views are my own and should not be attributed to the Attorney General himself or the state of California. But thank you. It's a pleasure to be here. Happy 2023. I don't think it's going to be a boring year for privacy. I will just say that.
Yeah, Stacey, first of all, thank you for joining us. And we more than understand that, these are your views, but also there may be times where during today's session, you will not be able to answer a question because it applies or comes out of an investigation or an active matter. And there's always, regulatory reasons. Our spokes community, as you know, is open, and we have folks from the government come quite a bit. So anything you can't cover, we certainly understand. But we really do appreciate you joining here today.
Great.
So,
and I'm in Northern California, and I was saying before that I really do hope that the power stays on. It's rather crazy climate here right now, but I'm going to keep my fingers crossed that everything will go well. But
believe me, again, if something happens, we understand. And there's been a lot of rain in the West Coast, and we get it. Totally fine. And if you don't mind, Stacey, one of the things we always do here before we jump into the substance is to have folks talk a little bit about themselves and how this became, an area that you've really ended up covering and developing some of the most important sort of cutting edge regs and enforcement matters in US privacy right now. So Stacey, do you mind giving just folks a few minutes about your background and
Sure.
some of the work you've been doing on the privacy front?
So I have been in privacy. I think this is my 10-year mark. I was the first deputy that was hired into the privacy unit that was established at the California Department of Justice by then Attorney General Kamala Harris. And in 2016, I became the supervisor of the privacy unit. We sit within the consumer protection section of the public rights division of the office. We have been, enforcing privacy law, both state and federal privacy laws since our inception. Our lives changed on June 25th, 2018, I believe it was. I always talk about how the day that CCPA passed and was signed by, I believe it was Governor Brown, I had to go for a walk in the neighborhood because I knew that my life was going to be just totally different. Since CCPA passed in 2018, I oversaw the team that was responsible for drafting the regulations to provide guidance and implement the law. Those regulations took effect in August of 2020. We began enforcing the law on the first moment that we could, which was July 1st, 2020. In addition to running the privacy unit, I also have been providing some support as the agency was coming into existence, because it was the California Privacy Protection Agency is the first state agency that's entirely devoted to privacy protection of the residents of California. And in that, in the statute, there was a provision that allowed those who work at the Department of Justice to provide support to the agency as it was getting stood up, because as the executive director has commented, they were both building the plane while it was flying and needed some additional expertise. I've since, fully returned to my role as the supervisor. I was kind of splitting my time, but as the supervisor for the privacy unit, and getting ready to continue with our enforcement.
Well, I mean, so Stacey, I mean, it's been a huge movement driven by California over these last few years. You may or may not know this, but Alistair McTaggart has been coming to our sessions now for several years, even around the time that CCPA was originally being adopted. And he's talked a lot about CPRA, and other members of the California government have as well. And the role you've played in sort of, as it was passed, issuance of the first regulations and now enforcement of CCPA and soon CPRA are really changing the way business is being done across the country. So there's a lot to cover. I could start on a number of different subjects, which I'm confident our viewers would want to hear. But are there certain things you'd like to cover just by way of an introduction? Because the California Department of Justice has obviously done some pretty important enforcement work. There was the public release around the Sephora settlement, for example, but then there's, I'm sure, a lot of planning going on as CPRA has gone into effect. So I'll turn it over to you just by way of an introduction for some items you'd like to cover on these, if that works for you.
Yeah, that's helpful. So as I said earlier, the privacy unit enforces state and federal privacy laws. We don't just enforce one law, although it's what everybody is always talking about is CCPA and our work around CCPA. We enforce, the Attorney General is the chief enforcer of all the laws. And so we have, very robust enforcement authority, particularly under the California Business Code, Section 17200, our unfair competition law, to enforce, to use any violation of any law as a violation of our UCL. And so that's why, for example, we enforce in the area of cybersecurity. In addition, I will talk more at length about Sephora and CCPA in a bit. I'm sure that's what, there's obviously, we're going to get to that. But for example, some cases that we've done previously, we filed a case, a settlement against a company called Glow. This was a case that was involving a fertility tracker that stored highly sensitive data relating to women's sexual and reproductive health. Its security practices did not violate HIPAA, in this case, the federal medical privacy law, but it did violate California's medical privacy law, which was built on top of the floor that was established by the federal law. And so we found that Glow's violations of the California medical privacy law, as well as California's reasonable data security law, we alleged violations of those laws, and we negotiated a settlement with that company as well. We've done work around cybersecurity in general and reasonable data security, as well as breach notification. We were part of the massive group of states that filed a case against Equifax when that breach happened. We also do what I call analog privacy data. We have a case against Aetna, where its mailing vendors sent letters to about 2,000 Californians that revealed through an oversized window in its envelope that its recipients were taking HIV-related medication, which went so far as to violate that. We allege that it violated the California Constitution. And then we also have, one of our older cases that we've enforced were against House, which was found to be recording incoming and outgoing telephone calls without notifying all parties on the call that they were being recorded. And California is a two-party consent state. And so that case was really significant because it was the first time that there were injunctive terms that were requiring, for example, a chief privacy officer in the C-suite. So, we've done a whole range of cases. We work on cases involving potential deception or misrepresentation, including in, a privacy policy statement, for example. And so, in contrast, for example, to the agency, which is tasked with doing administrative enforcement, which I'm sure we'll get to in a bit, administrative enforcement only of the CCPA. The California AG is the chief enforcer of all the laws, including CCPA.
I mean, that was, again, that makes a ton of sense. And it would make sense that you've been enforcing in general fairness, general consumer protection. I have a lot I would like to cover with you on the subjects you covered, especially because there have been some important developments on healthcare data and health advertising that perhaps we can cover in a little bit, Stacey, that, post Dobbs decision, you've probably seen that the Office of Civil Rights, it's HHS, has issued an important bulletin around advertising data and protecting it. And in my view, I think it's very, very complementary to what your office has been doing.
Yes, yeah, and when that case came out, the import of the enforcement action that we had against Glow became, really a very good illustration of why these types of cases are really important and critical, including the fact that, entities that handle sensitive information, including health-related information, really need to understand what risks are involved with handling that kind of data. So yes, I'm happy to talk about that in a bit as well.
Yeah, this will be an important discussion because this is coming up a lot, and I'll talk a little bit about the federal side of it, and maybe you and I can have that item on the bulletin from HHS. But if I may, obviously this was a big year for enforcement. When I mean this year, so 2022, big year for enforcement from the Department of Justice in California around California privacy rights under CCPA. And there's one major decision, obviously, one major enforcement action that's received a lot of attention. But do you mind if I just start with a broader question, which is, do you mind giving a little bit of an overview of the enforcement activity, enforcement priorities for the Department of Justice in California in 2022? Because again, the Sephora matter, I think, has received a lot of attention, but there was a lot going on from DOJ last year. Do you mind covering that a bit?
Sure. So, I mean, when people usually ask me how I was doing last year, I usually say I've been busy. And so I think part of that is, we obviously had the Sephora case, and we can go into greater detail on that in a minute. But we were doing a lot of investigation, as well as issuing, many notices of alleged noncompliance, which is part of what the CCPA required before bringing further enforcement. It was required that a company be notified of alleged noncompliance. It's interesting when you really parse the statute. It could have been an open question about whether that notice had to come directly from the Attorney General, or whether or not there was, there's room for an entity to receive notice elsewhere. But we were quite busy in terms of, issuing those notices, and, in terms of when there were areas in which we could provide examples of what notices and efforts to respond to those notices looked like, we would post them as case examples, similar actually to what HHS does, to provide some guidance and clarity towards what we were looking at and how we were approaching enforcement of CCPA. We were prioritizing, obviously, sale has always been one of the most unique aspects of the CCPA. And so looking at how companies complied with requests to opt out, including from both, in terms of both, disclosing that they were engaged in selling of information, personal information, as well as if they were responding to requests to opt out, if they were making those requests to opt out easy for consumers to exercise on their website, whether it was via, do not sell my personal information link, as well as responding to requests that were submitted via the user-enabled global privacy control. We've also taken some interest at looking at whether or not, for example, there was a dark pattern or deception involved with the right to opt out. That's been an area that we've also been looking at. Obviously, CCPA has a special protection for children. And so we also have been investigating how companies have complied with that aspect of the statute as well. And in addition, we do many things at the AG's office. It's not just that we're enforcing CCPA. So we're, constantly looking at, notices that are submitted to our office in terms of data breach security and whether or not, companies have appropriate and reasonable data security in place. So, I think that it's helpful to take a look at, for example, the case examples that we posted to sort of glean what, some of our enforcement areas were focused on. And I think it's actually very critical, especially because the requirement that there be notification of alleged noncompliance under CCPA is not, that's not language that was maintained when the CPRA amendments took effect, on January 1st, 2023. There is no requirement now that there would be notice of alleged noncompliance and an opportunity, a 30-day opportunity to cure that noncompliance. That's gone. That's something that AG Bonta was mentioning during his press conference discussing Sephora. And so, that for us means it's somewhat of a return to normal in terms of how we proceed with our enforcement. And so it could mean, for example, that we have informal engagement with a company that we think is in violation of the law. It could also mean that we head straight to issuing a subpoena to determine whether or not that company, if there's documents or testimony that we need to obtain in terms of determining whether or not there was a violation of law.
So this is an important point, and I want to highlight it. This means after January 1st, 2023, that notice and cure 30-day period's no longer there, and the California Attorney General can start with subpoenas directly or enforcement matters where there's an identified violation. Is that the way our folks should think about that, Stacey?
Yes.
That's an important one. And when you're saying glean information from the notices that are posted, obviously they're in the absence.
The notices aren't posted. There's brief summaries. It's not, we don't release the notices themselves because we consider that part of our investigatory file.
Yeah, I apologize. I used the wrong sort of shorthand. So no, but I appreciate you correcting me. When information is posted and folks should be paying attention, are there ways that folks who are processing these should really look at the information that's coming out about enforcement actions? Are there things you think people should be highlighting, or would you just recommend they follow the site?
So I think that with CCPA specifically, I think those examples, we try to telegraph how to approach compliance in a way that was recognizing that there's some complexity with the statute and that people are sort of having to, take advantage of this type of runway to get into compliance. And so there were, areas in which we were focused on, initially. We did several sweeps. We did some investigative sweeps, which I think are highlighted on the website around, for example, loyalty programs and financial incentives. We were looking at specifically disclosures that were not easy to read. We did that both based on, our experiences as consumers moving through the world, right? If you are posting a privacy policy, or if you're posting a disclosure and I can't understand it, right? Or if a consumer complains to our office that they don't understand something, that's something we will take, seriously and take a look at. Again, dark patterns in terms of mechanisms involving opt-outs, and, really just paying attention to how people are talking about exercising their CCPA rights. We would even look on, we looked at all of our consumer complaints that we receive from our office that, consumers complain about a whole host of different business practices, including compliance with CCPA. But we also took notice about how people were even talking about things on Twitter, and whether or not if there was something that there was a frustration with how a company was responding to CCPA exercising of one's rights. We took notice of that, and that could have resulted in, for example, a notice. So I think that there's a lot to look at in terms of those examples for how we were approaching this. I also think that there's a lot of information always in when we file a case, right? So I think that there is a lot of instruction that can be taken from the complaint and the allegations we make in a complaint, as well as how we are negotiating injunctive terms in the settlement document, because that sort of establishes what we think would be, appropriate for compliance efforts and potentially even, best practices. So, I think that those are also instructive documents, and that, people should really take a close look at those documents. The benefit of a negotiated resolution or entering into a settlement agreement with the state of California, we don't resolve anything in private. That's just not how we work. We represent the people. We don't make private agreements with companies if we've determined that they have violated the law. So the resolution of any type of investigation where we think that there's a finding that the law has been violated is either, in a negotiated settlement or potentially, filing of a litigated proceeding to litigation. And so the benefit, for example, of engaging in a settlement is that there's no admission of wrongdoing by the company or the target of the investigation. And so that is something that you'll also see in the documents, as well as the ability to negotiate terms and how it would apply to one's business. So, I think that that's important to understand in the context of reviewing those documents, as well as, to see what the facts that we allege, constitute a violation of the law. And then, perhaps if there's a negotiated resolution, there's not an admission of any liability as it relates to those facts by the entity.
And, for those joining, first of all, we have about 30 minutes, maybe a little bit less than that with Stacey today. And if you have questions, please feel free to post them to the Q&A. And we'll take them, Stacey, when we get a moment or so as we're going. You bring up some important points, and I think we should jump into the Sephora set of materials that are on the site. And it's very important what you've highlighted, because you've been very specific about describing them as settlements, and they sort of say what they say. But there was a lot of language in the complaint that was published involving the Sephora matter and the press release around it, around some I'll just say language that is in these documents on what that entire Sephora process really means. And maybe I could just start with asking you the question. That was a big, important matter that was announced. And there's a heavy focus on the user experience and what a consumer is shown and what they say and how the opt-outs and so forth are taken. So if you can, Stacey, and again, I know there are limitations to what you can say, but to the extent you can, talk about the Sephora set of materials and what folks should really be paying attention to there, if you can.
Sure. And I just want to point out that all of the materials are available on our website. So it's on the oag.ca.gov/privacy. I think you could see both the case examples. We have a special CCPA page. We are in the process of updating it. So it's not yet updated to reflect the amendments that have been provided by CPRA. So we are working as fast as we can. Again, that goes back to the response that I had, that we've been busy and it's on my to-do list. So yes, I know that it hasn't been conformed yet.
We'll understand. We'll understand.
So going back to Sephora, on August 24th, 2022, we filed our first enforcement action under CCPA. We allege that Sephora failed to disclose to consumers that it was selling their personal information, that it failed to process user requests to opt out of sale via a user-enabled global privacy control, and that it did not cure these violations within 30 days as provided by the statute. The company Sephora agreed in a stipulated judgment to pay a $1.2 million penalty to resolve these allegations. And so, I know everybody always has opinions about the amount of the penalty, but I think the injunctive terms have really been critical to also highlight as well. The settlement requires that Sephora clarifies its online disclosures and privacy policy, that it provides a mechanism for consumers to opt out of the sale of personal information, including via the Capital Global Privacy Control, the GPC. It also has to conform its service provider agreements to the CCPA's requirements and provide reports and updates to the Attorney General. That case was two different causes of action. So we allege that there was a direct violation of CCPA, as well as a violation of the UCL, the Unfair Competition Law, California Business Code 17200, that I referenced early in this talk, that with the specific provisions of the CCPA as unlawful predicates or constituting the violations of the UCL. And so that is a very powerful tool. Again, that's a very powerful statute for us to use. And so, I just want to make sure that for the lawyers, that there's two different causes of action. I think, again, this is a good example of a complaint to read the documents. But, if there's certain things that you want me to go through, but in conducting that investigation, we analyzed and reviewed how a consumer would interact with that website, in using consumer and commercially available tools to determine, whether or not, if I was a consumer trying to exercise my CCPA rights, trying to determine whether or not Sephora was selling data, and if Sephora was selling data, whether or not, how those opt-out rights would be processed.
Again, I'll put up a few quotes from the complaint, Stacey, but again, I know you can comment within a band, but these are some of the ones that have received a lot of attention. And again, to the extent you feel comfortable talking about these, one is before Sephora, there was and has been a fair amount of conversation around what is a sale of data under CCPA. That's a question that has come up a lot. What is a sale of data? And here's a couple of lines from paragraph 3 of the complaint. And this makes it very clear what, at least in the document, the Attorney General, view of the law is. If companies make consumer personal information available to third parties and receive a benefit from the arrangement, such as in the form of ads targeting specific consumers, they are deemed to be selling consumer personal information under the law. That's an important interpretation. And is there anything you can add to that in terms of this particular provision on coverage?
I mean, I think the statement definitely speaks for itself. When we undertake an investigation or when we are doing enforcement, we are using commercially available tools to look at the traffic and get a sense of what data is being made available and to which entity that data is going to. The definition of sale is very broad. And so it isn't I think the spirit of CCPA was, both the spirit and the actual language is intended to capture a range of how data moves, on, through a website on the browser. So we did a deep dive to analyze whether entities that are on a website, whether or not they were service providers with valid CCPA contracts in place. Looking at how the data is intended to be used, whether there were limitations placed on its use, of whether there was valuable consideration, which in the context of the amendments to CPRA now, with cross-contextual behavioral advertising there's no longer a requirement for valuable consideration. But we really looked at the contracts and tried to determine, what is happening in terms of the relationship between the first party business and the third parties on the website and whether or not they did satisfy the service provider exception to sale. And so that's part of what, our analysis and our approach to this case was.
Well, and that's, again, this is an important one because we're talking about, and this is why I started the discussion today saying this is an important thing for folks to pay attention to, because advertising, digital advertising and digital marketing, as covered by some of the items we're talking about, are now a regulated industry if you're doing business in California, and you have to pay attention to these things because some of the techniques we're talking about, Stacey, are widely used ad tech, tech techniques. And so here was another quote from the complaint that's in the same vein, which is the trade of personal information for analytics and the trade of personal information for an advertising option constitute a sale of data under CCPA. And this is language that basically says, and if you're using personal data to serve an ad, improve an ad, measure the performance of the ad, or other similar analytics, this could be covered as a sale of data under CCPA. Is that a fair reading of what I'm saying here?
I just want to be mindful that there's, specific facts to every case that we contemplate and we look at. So I can't say unequivocally, across the board that this is always the case. But I think that, that is an accurate recitation of what's going on. We did we are looking at what the potential benefit was, and the relationship between companies, as well as, for example, if there is an opt-out, if there's, a certain restriction placed on the data when it goes to a third party, whether there's an obligation that there's a restriction placed on the data when it goes to that third party, and if that obligation is being undertaken. Again, it doesn't matter necessarily, how the data is, how the third parties are on the site necessarily, right? Like the technology, the tracking technologies that are utilized. It really mattered in terms of, whether how the data was being made available and what the relationship between the first party and that third party is, in terms of what they're understanding, in terms of how that data could be used, and whether or not it rose to meeting the legal definitions or the exception in this case. I think it's also a really important and critical exercise for entities to know what are on their sites, right? You don't want to say, oh, I don't know what's on the site either, and have me figure out what's on the site, and there be an inconsistency. Doing a type of inventory and knowing things that are on your site, or like what is embedded in terms of on your site, and getting access to traffic or personal information that could be made available to those entities on your site is really a critical piece of how we are approaching enforcement.
Yeah, and transparency is obviously critical. I'll spend just one more minute because part of it is in the complaint covers what is a sale and what is, and obviously it's in the document itself. So I don't want to put you in a position where you have to explain it. But then the complaint also talks about what you have to do from a user experience to enable somebody to make a choice not to have the data shared that way. And obviously, there's been discussions of the global privacy control or a general user experience, but this language again in the complaint caught a lot of folks at the moment. I think that it came out a few months ago in August, that you not only have the requirement to enable somebody to opt out manually, but you have to have a user-enabled global privacy control that does it in a touchless manner and is treated as somebody clicking the link manually. And this is something that was in the statute, but do you mind talking a little bit about these technical requirements to the extent you can?
I mean, that was a perfect way of saying it, that there should be no difference between a user that clicks on the do not sell my personal information link and is trying to opt out of any sales, or versus a user that is communicating or signaling a user-enabled global privacy control, including the GPC, via a browser extension, for example. It's supposed to be treated the same way. And the language in which the regulation that requires this, that's how it's contemplated, right? As long as there's some basic thresholds that are met, which, here the GPC does that in terms of communicating or signaling that a consumer is opting out of the sale. So I think that that's basically saying it very well, that companies, need to consider whether or not they are processing complaints that are via the GPC. And that is, an important takeaway from Sephora.
Again, I don't know if this is something you can cover, and it's fine again, but one question that comes up to us a lot is the term global privacy control. It was written in lowercase letters in that complaint. There are also organizations, nonprofits that are called global privacy
GPC.
control with capital letters. So when I read the complaint, my interpretation was that the Attorney General's office is asking for a lowercase global privacy control. And there's also the capital globalprivacycontrol.org. Am I reading it right that the complaint was referring to the generic mechanism and not necessarily the organization specifically, or was it meant to refer to the organization specifically?
Well, I think it's been pretty clear, and there's been other statements that have been made regarding the GPC, the organization, and the actual technology, the GPC, as the being able to meet the requirements of the regulation, which refers to a user-enabled global privacy control. And so, the regulation, the law is broader, obviously, than the organization, the GPC, but the GPC is a mechanism by which the regulation, it satisfies the regulation. And so there's a contemplation that, as other user-enabled global privacy controls emerge that meet the requirements of the law, that those signals also should be processed. But right now, the GPC does that.
Got it. Okay, perfect. So if somebody's using the global privacy control by globalprivacycontrol.org, that is an acceptable mechanism, but there may be other protocols that can be used in the future.
I think that's I think you could take that away for sure, based on the Sephora.
Terrific.
And things are changing, but and there's still some the regulations that are forthcoming by the agency go into a lot of depth about user-enabled global privacy controls, which I think actually is now changed. The language is called the opt-out preference signal. And, I know that there's been discussion about whether that's optional. I do not read that as, I don't read the statute in sharing. That is not how I see it at all.
So in other words, to the extent people believe that a global privacy control signal is optional, not accurate.
I think you have to read the statute in its entirety.
Fair enough. That sounds great. We have a lot of questions, and we haven't even gotten to a whole bunch of subjects that you and I were going to cover, including there's a whole bunch of rulemaking items, DOJ versus the new California agency. Maybe I'll just ask one or two, and then we'll jump into questions. I'm not shocked that we're kind of overwhelmed with them at this point. First, maybe talk, if you don't mind, Stacey, about the California Department of Justice and the new California Data Protection Agency. What are the goals between the two, and is there still coordination, collaboration in the rulemaking process and otherwise?
Okay, so I had a fancy slide. I should have shared that with you with just a comparison, but I'm going to try to run through this verbally, and hopefully I can make it as clear as possible. So the Attorney General is the chief enforcer of all the laws. The agency is enforcing the CCPA. the Attorney General continues to enforce the CCPA because the AG enforces all the laws, and the AG continues to enforce those laws via civil enforcement or in court. We are in what you would consider, traditional civil enforcement, subject to approval by a judge. The agency is in charge of resolving its cases via administrative enforcement. Administrative enforcement is a different type of legal proceeding that's quasi-judicial in nature and it sits in actually the executive branch, not the judicial branch of government. It typically involves like an evidentiary hearing where the government agency here, the CPPA, is reviewing evidence and that's submitted and analyzed by an administrative law judge. And there's an interpretation about whether the law has been violated. How the actual procedures are going to play out, I don't know yet, and that remains to be decided. But that is where, the board, for example, could review a proposed decision or a proposed reasoned decision by an ALJ to make a final decision on whether they agree with those factual conclusions. And so everything really happens within the agency, as opposed to me that has to, navigate a civil court enforcement. The Attorney General has investigative authority under Government Code 11180. It's very expansive authority to investigate violations of laws or rules or any matters. We have the ability to issue subpoenas, administer oaths, and take testimony by witnesses, including third-party witnesses. So we have very broad ability to conduct, inspect and copy books and records. We have very broad authority to, document requests, for example. The agency has investigatory authority under the CPRA Amendment 1798.199.65. They also have the ability to subpoena witnesses, take testimony, but they also have they have the ability to do audits. I think technically audits are similar to us being able to go in and inspect and copy books and records as provided under 11180, but they're going to be hiring somebody who's going to be a chief auditor. And so that is a new type of, a little bit of a shift. The other, with respect to CCPA specifically, the AG does not have any more requirement for a notice for alleged non-compliance and 30 days to cure. The agency has discretion to allow a cure. I would argue that we also have discretion in general. We exercise prosecutorial discretion in everything that we do. But if there's a violation of law, I think that is really what focuses our analysis. The Attorney General is not going to engage in any more rulemaking under CCPA. That authority transferred directly to the agency, and that's why you've seen so much going on in terms of the agency, endeavoring very hard to write regulations to interpret CPRA. And the other very big thing which comes into play here is that the head of the Attorney General's office is the Attorney General. There's one person in charge, right? And he oversees many different aspects of the Department of Justice. The leadership of the agency is a 5-member board that is subject under California law to an open meetings law known as Bagley-Keene. You may, if you watch the meetings happen, seen the chair reference, Bagley-Keene. And that is a much different structure in terms of process. Bagley-Keene regulates the fact that public agencies exist to conduct the people's business, and proceedings must be conducted openly. So, for example, you cannot do anything outside the public view, which is why you've seen the agency post text of the regulations initially before it even went and published them through the Office of Administrative Law. It's because it had to give the board the opportunity to review the proposed text, provide and receive public comment on that, and then vote as an action item whether or not to proceed with rulemaking. And so you're going to see that more. You're going to wonder why it seems somewhat duplicative, like why aren't the rules final yet? Because there is a different layer and process that has to happen right now with the agency before rules can be finalized and then submitted to another state agency. So it's bureaucracy, right? Another state agency for final review and and to make a determination of compliance with the California Administrative Procedures Act. So things look different,
So
right?
it's totally crystal clear.
look,
Yeah, no, but no.
yeah,
I bet you have
things
to
look
explain
different,
this a lot. Yeah, I would say.
right?
Yeah.
And people, I understand people are like, just tell us what the regulations are going to be. But there is process in place to make sure that the public is engaged with these processes, because that is what the legislature decided was, very important in terms of creating state agencies. And the agency has been working tirelessly. I know this for a fact. And so.
Well, there's a lot to cover. By the way, it's always impressive to me when somebody can quote code subsection point on the fly over and over again. That was pretty, you must have thrown out 8 different sections in that last discussion, just so you know. It's impressive.
Well, a little bit of rewinding is going to happen.
Yeah.
Yeah.
So many of them. And but right now, is the California Department of Justice and the Attorney General, are they involved in the rulemaking process, or is that all going on in the agency, in the new data protection agency?
So rulemaking is sitting in the agency for CCPA. That is entirely being done by the agency. DOJ has been providing support to the agency while rulemaking has been happening, primarily in terms of staffing. And so, that is to make sure that the things that we understand and learn about the process of rulemaking, they didn't have that in terms of having staff already ready to go for rulemaking, because they were created from nothing.
Yeah.
So
it makes a ton of sense, and
a huge challenge. Yes,
I can imagine trying to stand this up on the deadlines we're talking about, Stacey.
During a global pandemic too, right? This is, they're moving mountains.
Well, I'm going to jump in on some questions because I know you're going to run out of time. So how about coordination between California and the Attorney General's office and states, Colorado, Connecticut, Virginia? I mean, there's a broad set of states coming online. You and I know that there may be something between 9 and 32 different consumer choices that may become mandatory across all of the states, and companies are struggling with this. So is there coordination going on? And do you know if California has thought about some kind of coordination on that single link about, your privacy choices, for example?
Yes, there's always coordination, right? There's coordination. There's coordination intrastate, for example, right? There's the AG oversees, like as the chief law enforcement, works with district attorneys' offices all the time. We've had joint cases with DA's offices, and city council and county councils, for example. There's always coordination. There's coordination that's always happening within the state. There will be coordination going on with the agency for sure. And then I've always been part of a multi-state group of attorneys that, my counterparts in other states for coordination. That's how, for example, the Equifax case resulted. There's coordination with federal partners. There's even coordination at times with our international partners and lessons learned from international partners. So there's always coordination. We're always talking to each other. We're trying to make sure that we are thinking about things and, bouncing ideas and being, hopefully somewhat consistent in how we approach things and how we approach enforcement. When I read other statutes in other states, I see that compliance with all of the different state frameworks is possible. It's not something that there's not conflict. There's extra work that could be involved, but as we've seen, there's every single state in the country, and I believe the territories have a data breach notification statute. And so what happens is that, you have to comply with the most rigorous requirement, and that should satisfy the less rigorous requirements. I think that right now, because every, CCPA enforcement or comprehensive state privacy regime enforcement, we are going to continue to talk to each other and think about how to utilize our resources in the best way possible. So I envision a world where there's, collaboration.
Yeah, I mean, again, it's great to hear. And I think one of the things when you get into dark patterns or trying to simplify the information for consumers, Stacey, that comes up a lot, is just imagine a regime that you have your privacy choices for California, but then you have to do one for a separate one for Virginia and Colorado. And there's some hard user experience simplification issues. And I think what was probably coming out in the question, if I were to paraphrase it, is if the states were to coordinate and they were to unify on one thing that companies could post, and it would at least simplify where it can be simplified across the 5 states, you might make it easier on consumers. So I think the question was, is there that kind of coordination going on, or is it general coordination as far as you know?
I can really speak more to general coordination and enforcement coordination. A little bit of the question is touching on like coming up with some sort of like uniform standard. And that is something that's, potentially happening during rulemaking right now. I know that Colorado is engaged in rulemaking as well. And so I don't want to speak for that rulemaking. Obviously, I can't. But I think that, from an enforcement vantage, approaching this to make sure that things are clear to consumers, I think is the most important thing.
Yeah, and it's a hard job on the regulatory side. I think speaking for companies where they're trying to do the right thing, it is also quite difficult, even if they're trying directly. We are not going to get to many questions. I would just because you and I have chatted about this, I did want to put up the at least one point so we could spend a moment on it. HHS has published a bulletin from the Office of Civil Rights on tracking online. I'll sort of paraphrase. Online tracking technologies to protect the privacy and security of health information. Stacey, if you read this is broadly trying to enable people around the country to have a choice on whether their data is shared, for example, from a website, tracking from a website or a mobile app, to a third party when you land on a site where the company may later collect HIPAA data. And when you read this, it really does parallel a lot of the efforts that you were covering earlier in terms of California trying to protect arguably healthcare data that's being tracked in the form of ad tech. I think we covered this a little bit, but have you had a chance to review the federal guidelines, and are there any coordination between the California Attorney General and the federal government on these kinds of issues, if you're able to speak about that?
I will just say that I thought that it was interesting that they used the phrase online tracking technologies, which was very similar to the language used in the Sephora stipulated judgment. And so, we're living in a time where there's a lot of information that's not always characterized or covered by HIPAA because it's not necessarily falling into the framework of HIPAA because it doesn't necessarily derive from, like, for example, a covered entity or a business associate. It could be medical information or the same type of information, but used for a business by a business or a non-regulated HIPAA entity. And, that information should be protected too, especially in the context of deeply personal medical decisions that people are trying to make. And, the Attorney General filed a comment to the FTC in response to the ANPRM, where it made Attorney General Bonta filed his own comment, where he discussed the need to protect medical information from going to third parties, as well as use reasonable security to protect that data in a way that's similar to the protections that are afforded by HIPAA. And I think there's a recognition that there's a lot of sensitive information that could be made available to third parties that could then be used and accessed in the context of, for example, law enforcement that could really cause direct harm to somebody. And so thinking about what data you're collecting and how it could be used in a harmful context, and whether or not there's tracking technologies that belong on all of different parts of your website, I think is a rigorous activity that might be an important one, especially in the context of minimizing that type of data.
Yeah, my read of it, I know you have to go, is that if you're doing a lot of what you have to do for Sephora, you're probably putting yourself in a good position under that new HHS bulletin, because you have to govern a lot of that advertising technology and give a person the ability to opt out. But I know you had a hard stop, Stacey.
Yes.
I can thank you on behalf of everybody that has attended and will watch our Privacy Week session, for coming and joining here. We'll get you, there were many questions we didn't cover, so we'll at least send those your way, so that if you have the ability to talk about it in another session, at least you know some of the questions that are coming up from the community. And thank you for everything you've been doing, in terms of protecting privacy of folks around the country. And we hope you can join us again sometime soon.
Thank you very much. And I hope to see you in person, and, don't be shy, come over and introduce, to those on the webinar. I'm very excited to see people again, so it will be fun. But thank you so much. And thank you for having me.
All right. Thanks again. Thanks, everybody.